So, I guess you heard me. Discussing issues surrounding competition law and innovation. And as all of you who have been working in this field will have experienced one way or the other, it can be incredibly complicated to get these groups together in one room and to talk to each other. You can be able to do this one time, but oftentimes they will run away and say, okay, that was the worst experience I've ever had. So it's an ongoing endeavor, and it's part of our mission. As you can see, so there's current directors include Achim Bambach, who is the head of the German Monopoly Commission, so he's an economist, as well as the others are. I'm the only lawyer in the board of directors there, but as you can see, I survive. What we do here is to provide a platform for an exchange of thoughts between lawyers and economists around innovation and competition. And one of the landmark projects that we have been done over the last 1.5 years is this project here, which brings us together today for this conference. It's a joint project of the Center of Technology, Innovation and Competition of the University of Pennsylvania, whose director, Professor Christopher Yu, is. And the unique thing about the center is it not only brings together lawyers, economists, but also technology guys, which is incredibly important for many of the fields arising, for many questions arising in the connection between competition law and the digital economy, for example. I will come back to that in a second. The second partner is Professor Yong, who is, I would say, the leading expert for competition law in China, who is heading the Center for Competition Law at UIBE, the University of International Business and Economics in Beijing. And this project is a multi-year project, so it's designed for 3 years, and we have different phases of this project. And the first phase that we are currently in the process of finishing is the one that brings us together here. It's due process in competition law. And the idea is to compare different jurisdictions and see how they address similar problems or similar challenges if it comes to competition law and due process in competition law, and to figure out what we can learn from each other. As you can see, we already started with phase 2, which is dealing with big data, AI, algorithms, and competition law. We had a kickoff conference in Brussels this Monday, so we will finish this next year. And the reports and the report that we're going to talk about, or what we want to talk about today, always have a descriptive part saying how is the law, how is the practice in the different jurisdictions, as we think the 3 major and most important economies and jurisdictions if it comes to competition law, but also a normative part, how could the law be improved learning from each other. As I mentioned earlier, we're currently in the stage of finalizing this report. So for us, it's an incredible, unique opportunity to discuss these issues or major issues today, because we are all academics, and sometimes it's really important, or not only sometimes, it's important to get input also from practitioners who do this every day. And therefore, we are not only grateful to have judges, to have people from the European Commission, but also practitioners in this room who can hopefully share their thoughts with us. Having said that, I should have said one housekeeping rule, which is essential. The mic was not only turned on in order to make it easier for you to understand me, but also because this event is going to be recorded. There's also video recording. I'm not sure if there is a live streaming. There's no live streaming, so no worries about that. We can always cut out things that you don't want to be heard in public afterwards. But since we're in Europe due to GDPR and other legal regulations, I want to inform you that everything that you are saying is potentially recorded and can be used afterwards against you, what we, of course, will not do. Having said that, I would again express my gratitude towards all of you coming to this event, spending the time with you, and I'm looking forward to a hopefully productive and interesting, inspiring conference workshop today. And with that, I will hand over to my colleague and friend, Professor Christopher Yu.
Well, thank you, Thomas. I mean, I would like to thank you all for coming and to really emphasize the nature of the project and why we think it's so important. This is an issue, due process and enforcement, for those of you who are following the issue, is becoming a major international topic in many, many circles. So Among other things, there is a discourse going on in China right now as they consolidate from 3 enforcement agencies to a single agency. They're having to unify what had been previously disparate policy procedures, enforcement procedures, and they're in the process of trying to distill the best of each of those and also of outside learning. So it's a really wonderful opportunity. We presented this work in Korea, where they're currently another very active enforcement authority, where they are in the process of revising their Administrative Enforcement Act. And in fact, they're going to early next year will translate the entire report into Korean and subject to bring in Korean commentators. We presented it in Taiwan. And for those of you who follow this, this has been an enduring subject for the interest for the International Competition Network, which has an ongoing practice on a project on due process. The American Bar Association has an ongoing project that's studying this, and in fact, with collaboration with us, we're hoping to do an event at the spring meeting in April in Washington, D.C. But in addition, the US Justice Department is actually leading a multilateral initiative on due process, and the OECD is reviving working group number 3. In fact, they're scheduled to have their meetings next week in Paris to really begin to focus on due process and international goal and try to find ways to push this forward. So we feel very fortunate that we started this at a very fortuitous time. We're very grateful for the research partners, as Thomas is leading Maki, which is, again, as well respected as one of perhaps the leading economic school in all of Germany and a leading competition law center. I'd like to also acknowledge Hendrik Wendland, who is here as well. He is currently an attorney at Freshfields and a doctoral candidate under Peter Müller-Graf at Freiburg, and he was instrumental in pushing this project through its early stages. And Professor Huang Yong, as Thomas noted, is among his many hats as a professor and otherwise, is the deputy head of the expert group for the Anti-Monopoly Commission in China. And for those of us who know how this works, is the formal head of that group is a former government official. He's the academic, as the deputy chair, he's in charge of putting together the academic programmings and is really the intellectual force behind much of competition law in China. So we're very grateful to have them as a great team collaborating together. And so we are excited about this project. We're delighted by the reception it's received from you attending here and the informal comments we've received before, and we're very grateful to all the speakers today who are making this event as special as it is. So without going any farther into the welcoming remarks, we'd like to thank you all for coming. And I will go to my second duty, which is to introduce our keynote speaker, Giovanni Pitruzzella. He needs no introduction here as an Advocate General of the European Court of Justice, but my personal pleasure is we found in the Due Process Project, it actually crosses between competition law, which is traditionally seen as private law, and public law enforcement. And Giovanni, as the former head of the Italian Competition Authority and a professor of constitutional law, is uniquely well suited to provide a combination perspective of both of these fields. So without further ado, Advocate General Pitruzzella.
First of all, I would like to thank the conference organizers very much for inviting me to deliver this keynote address. It's an honor and a pleasure for me to attend this conference and discuss such stimulating topics. I believe I will learn a lot from such authoritative speakers who will animate the upcoming panels. Ladies and gentlemen, distinguished guests, competition is an essential tool to promote economic growth. As a consequence, several countries around the world are empowering public agencies to enforce antitrust law. It is noteworthy that the global group of competition law authorities, known as the International Competition Network, ICN, includes more than 130 countries. Leaving aside efforts to strengthen private enforcement, competition law relies heavily on public enforcement. Adherence to basic principles of due process has long been recognized as an essential aspect of proper competition law enforcement. There are several initiatives at international level which aim to strengthen these aspects. with a clear objective in mind. Consolidating due process in competition law enforcement brings the safeguard of fundamental rights together with a better quality of decisions adopted by antitrust agencies. However, the topic is very sensitive and debated all over the world, and the debate shows a trade-off between administrative costs and error costs, deterrent effect and effective protection of fundamental rights. Decision-makers carry out their fact-finding tasks in conditions of uncertainty, since they must reconstruct past events that are not subject to direct observation. Determination of fact always entails a risk of error. How should the risk of error be allocated? What is the burden of proof and the cost of administrative procedural restraints that competition agencies can bear without jeopardizing the effectiveness of their function? In striking balance, it is important to underline that competition enforcement entails several fundamental rights, such as the presumption of innocence, the right to effective judicial review and fair proceedings, the right to privacy and protection of correspondence, or the principle of legality and proportionality of criminal offenses and penalties. In Europe, we also have to deal with a multi-level system of protection of fundamental rights, so that competition enforcers must comply with European Charter of Fundamental Rights, the Convention of Human Rights, the European Convention of Human Rights, and the national constitutions. How to coordinate this different set of rules is a big concern both to antitrust enforcers and judges. And another overarching concern is how fundamental rights, especially criminal law type of guarantees, can be applied within administrative procedure which regard only undertakings, not individuals. Notwithstanding the engagement of European competition agencies and judges in assuring the protection of fundamental rights in antitrust enforcement, the debate is still intense. Many practitioners criticize the behavior of the Commission and the national competition agencies and call for more judicial review. Sometimes these criticisms are based simply on disagreement about what facts need to be proven. As Castillo de la Torre and Gippini Fournier wrote, the stricter standards of review of proof proposed often aim, in reality, at introducing the analysis of certain facts in the definition of what should constitute an infringement, yet the definition of prohibited conduct is a legal issue that, although influenced by economic reasoning, has nothing to do with the standard proof, though it is very often confused with issue of evidence and proof. In this context, I welcome the study presented in this conference on due process in antitrust enforcement, China, Europe, and US, which provides us with fundamental wealth of information on the topic, a framework of analysis which allows us to have a deep insight into the relationship between antitrust enforcement and due process, and concludes with fruitful proposals. In particular, I would like to stress the ability of the research to cover all the aspects of competition enforcement. In fact, the report analyzes antitrust enforcement process on the basis of a 6-phase framework. 1, investigation, 2, inspections of company premises, agency deliberations, issuance of decisions, settlement, and at last, judicial review. After discussing the chosen steps for each phase, the report analyzes the similarity and differences across jurisdiction, comparison, are complicated by broad differences in the three jurisdictional legal system. For example, think of the adversarial tradition of the US legal system, wherein judges are supposed to be neutral arbiters between opposing parties, and the system adopted by the Commission and in Europe by national competition agencies, which is inquisitorial. Although the report acknowledges these broad differences between the three legal systems and does not presume the superiority of any particular legal system, it ends with some recommendations. The report sets out three procedural requirements that are considered essential to achieving rational, fair, and transparent agencies. First, agencies must allow investigated parties to access the evidence against them. Second, agencies must separate functions. It is fundamentally unfair to let a prosecutor to be the judge in his own case. Third, judicial review must be available and rigorous. Without these protections, rational decision-making, due process, and transparency will be practically impossible for a nation's agencies to achieve. But, in my opinion, there is a premise of effective due process: the independence of the agencies empowered to enforce competition law. The report does not take this into account, but without strong independence from political and economic power, the possibility of undermining the due process before competition agencies is always present. In light of this remark, I believe that the final approval of the proposal for a directive to empower the competition authorities of the member states to be more effective enforcers and assure the proper functioning of the internal market will be of the utmost importance. The EU member states are essential partners of the European Commission for enforcing the EU competition rules. Since 2004, the national competition authorities of the EU member states have been empowered by Regulation number 1 of 2003 to apply the EU competition rules alongside the Commission. For more than a decade, both the Commission and the national competition authorities have enforced the EU competition rules in close cooperation in the European competition network expressly created for this purpose. All this has two main consequences. Firstly, to assure the effectiveness of EU competition rules, the institutional structure of national competition authorities is of great importance. And secondly, when we discuss due process in EU competition law enforcement, we should consider not only the practice of the Commission and the judicial review delivered by the Court of Justice and the General Court, but at the same time, the way in which national competition authorities act and the judicial control to which their acts are submitted. Returning to the report, I think that it is very challenging for the enforcement of EU competition rules. In particular, among the different points of interest, I would like to stress some developments in EU competition law enforcement which regard a meaningful judicial review. I will make just a few remarks on these issues, which will be discussed in depth by distinguished speakers in the following panels. Going on, in a very asystematic way, I will begin underlying the decline in competition cases decided by the European judges. It is easy to see over the years a constant decline in the number of competition cases decided by the General Court, which was considered the competition court of the European Union. This phenomenon is due to the decentralization of EU competition law, which has led to a situation in which national competition authorities and national courts play a much more important role in its enforcement than before. So, nowadays it is more common for the Court of Justice to be called upon to hear a competition case at the request of national courts using the preliminary ruling procedure before the Court of Justice rather than in the course of an appeal lodged against a judgment of the General Court. Landmark rulings such as T-Mobile, Tele2 Polska, Expedia, Con have been delivered by the Court of Justice at the request of the national courts. The second aspect of Regulation number 1 of 2003 that has a direct impact on the number of actions lodged before the general courts is the success of the commitments procedure, of the Commission's leniency program, and the settlement procedure, which render undertakings less likely to challenge such decisions. The question which arises is whether the sharp reduction in the number of competition cases brought before the European courts could weaken the importance of judicial control and its ability to limit the Commission's power and to oblige it to effectively respect due process. If we move from the number of cases decided by the courts to the outcome of the judicial review, it is generally observed that DG Comp's decisions are rarely quashed by the courts. Is this evidence of the inadequacy of judicial control? I shall leave the answer to the following panel, but I suggest that divergent interpretations of the above-mentioned trend may be possible. The first could relate to good prioritization and high quality of work. The second, to the success of the leniency program, which enables the Commission to obtain accurate information and evidence. In any case, the above considerations lead me to pose the question of the interaction between administrative and judicial proceedings. Is there or is there not a coincidence between the standard of review and the standard of proof? How can the existence of an adequate system of judicial review influence the administrative procedure before the Commission and the national competition authorities and the effective protection of fundamental rights? In this perspective, it is important to determine the scope of the European Court's review and powers. Judicial review of competition decisions by EU courts comprises two distinct aspects: review of legality of the Commission decision and review of the amount of the fines imposed by the Commission. These two different tasks differ significantly. The finding of the decision, other than the fine, are subject to a review of legality only. Article 261 of TFEU provides that regulations made by the Council pursuant to provision of the treaty may give the Court unlimited jurisdiction in regard to the penalties provided for in such regulations. Article 31 of Regulation 1/2003 provides the Court shall have unlimited jurisdiction to review decisions whereby the Commission has fixed a fine or a periodic penalty payment. It may cancel, reduce, or increase the fine or periodic penalty imposed. The rulings KME and GALP stated that the unilateral jurisdiction only covers the sector of fine. That the unlimited jurisdiction only covers the sector of fine. Consequently, Article 261 does not permit the EU courts to ignore the limits of their powers of judicial review under Article 263 by recasting the decision and the review or issuing instructions to the Commission as to how it should implement an annulment. The Court of Justice, in a ruling of September 2018, has reaffirmed that the General Court cannot substitute its motivations to that one of the Commission, and that the competence of a limited jurisdiction regards only the setting of the fine. In any case, issues of judicial review engage the right to a fair trial, and therefore it is of fundamental importance to examine whether the case law and practice are in line with Article C of the European Convention on Human Rights and Article 47 of the Charter of Fundamental Rights. The case law of the European courts must consider the jurisprudence of the Court of Strasbourg, which has developed the concept of full jurisdiction. For a system where an administrative decision is adopted first and then reviewed by a judge to be compatible with Article C of the European Convention, the court must exercise full jurisdiction. Full jurisdiction includes the power to quash in all respects on question of fact and law the decision of the body below. With regard to competition enforcement, the concept has been used in the Menarini judgment in 2011. The case involved the Italian Competition Agency, which follows the same system as the Commission, with the authority investigating and determining the matter subject to review by court. The European Court of Human Rights found that, in view of the amount of the fine, the matter was to be classified as criminal for the purpose of Article C of the Convention. Some years later, another judgment of the court, the Grande-Stevens ruling, confirmed the criminal nature of the fines adopted by another regulator. In the Menarini judgment, the European Court of Human Rights rejected the applicant's argument that the judicial review of legality exercised by the competent court over the agency's decisions was insufficient. Although the competent powers of review of the domestic court were classified by the law, by the domestic law, as limited to a review of legality, the European Court found that, in fact, the competent court's powers enabled it to exercise full review over agency's decision. The power of annulment of the EU courts is quite extensive when it comes to the findings relating to the constituent elements of the infringement. The court must verify the accuracy of the facts. It can annul the entirety of the finding of the Commission, but also redefine the offense. The EU courts have the power to quash in all respect on question of fact and law the administrative decision. Consequently, the General Court and the Court of Justice have rejected pleas contending that the judicial review was insufficient. Nevertheless, there are still authors not convinced that the standards applied by the EU courts respect the case law of the European Convention. I have spoken too much, and so I shall stop. Looking forward to the interesting presentation which will be delivered by a very distinguished group of antitrust specialists. Thank you very much for your attention.
Well, thank you very much, Advocate General. It is fascinating to me that your remarks remind me of many facts that have been challenges in this proceeding. In our research, one of our goals was to try to put the evaluation of different due process measures on a sounder empirical footing to validate what would actually contribute to better outcomes. And one of the great problems we have is that there is actually no ground truth of actual proper outcomes that's independent that you can resort to, unlike in other areas of empirical study. And actually, your remarks remind me of a famous saying, in hell there is only due process, which is we forget that due process is in service of larger substantive goals. And to talk about them divorced from that, I think your early remarks really remind us of the importance of remembering that it is a balance and that we have to make sure that that works properly. And you did call to mind what's really interesting is we have very different systems, and the whole legal systems, not just adversarial versus inquisitorial systems, but the Chinese and the EU systems, while both inquisitorial, are quite different. And what struck me is that in many ways, the adversarial versus inquisitorial distinction doesn't fully capture the third way, which is the administrative decision making, where the real justification is not the independence of the judge in a full judicial proceeding, but rather draws on the expertise of the agency in attempting to balance that. But what's interesting is the full judicial independence of judges that provides a lot of the balance in a true inquisitorial setting is in many ways absent from, is a different consideration in administrative decision making, because they are not independent in the same way that we think of as judges. They are accountable in different ways. And actually, I've attempted to find literature in the academic writings to really explore that difference, largely without success. Because I do think that we generalize from the inquisitorial judicial system to the administrative system perhaps too quickly. And that in fact there are many strengths to the administrative system, but also differences that are somehow lost by simply equating it to the way we do civil procedure in traditional civil law courts. And so I actually think, I find your remarks, and particularly about the independence of the agency from political and economic power, as something that's given us tremendous food for thought, as well as the structure of the unique structure that is the EU between the national competition authorities and DG Comp. So I find your remarks tremendously inspiring. It does bear in mind, we initially had styled this as a presentation of our final report. We realized that there's a certain arrogance in presuming that we would have the final report before the discussion that will ensue. So we will freely take back that denotation of finality and reserve the right to actually to improve and adjust the report based on what we learned here during today's proceedings. And also, just so you know, we actually did a preliminary presentation of what we thought would be a final report in China about 3 weeks ago. And again, learned so much that we are likely to take to the end of the year to continue to revise and improve the work before we submit it for academic publication. So in all fairness, it is, we welcome your participation in what we would learn from it. So my next job actually is to, I guess seamlessly, is to start to give a basic introduction to the project and to try to frame the work that we're doing. And I've had the advantage of both Professor Fetzer, my colleague, and the keynote speaker doing this in many ways far more effectively than I could. So it solves some of my need to go into some of the detail. As you know, we are 3 participating institutions, 1 European, 1 American, 1 Chinese, to reflect probably the most active enforcement agencies and the ones that are the most, have the most influence. This is part of a multi-year project, a multi-phase project, and this is wrapping up the end of phase 1. And we really do have a comparative approach, but there is an attempt to give a normative and a theoretical foundation to it. Because straight comparative law without some sort of theoretical foundation can only identify differences without providing a basis for understanding how to reconcile those differences. Because we could reconcile them by all becoming like the EU or all becoming like China or all becoming like the US, and that would solve the comparative law problem. But it leaves open the question of how to, on what basis you would actually do that reconciliation. And so the whole comparative law method presumes that we do have something to learn from studying how other jurisdictions deal with things, that there are differences, but there are generalities that matter and that we can learn from glean from looking at other jurisdictions. And so we tried to do a fairly detailed analysis, as Advocate General Pitruzzella pointed out. We divided the entire enforcement process into 6 large phases consisting of 28 smaller phases, and did a point-by-point comparison of each of those. And I won't belabor them all with you today. What I will do is briefly talk about the theoretical underpinnings about why we're doing what we're doing, why due process matters, and to highlight some of the primary responses, the recommendations we're making with an eye really for a European audience, because many of these things are very familiar and less of an issue on the 3-way comparison in Europe than they are in other jurisdictions. So in terms of the theory, there are some basic notions of impartiality, and I always hesitate before citing Roman law to civil law audiences. I remember when I go to Professor Fetzer's institution, I'm always struck by how very much alive dead Roman law is in Europe. And there's two very well-known aphorisms from Latin. Actually, I'm quoting British common law when I say nemo judex in re sua, but it's a fairly general principle that no one should be a judge in their own cause. And in a limited basis, perhaps in its original genesis, it was limited to having a financial interest in the matter. But we all understand that, in fact, what we see certainly in US case law, we are concerned about not just financial interests, but different professional interests, prosecutorial zeal, advancement of one's career can be as important as direct financial payment. But regardless of actual bias, and this is where I think in part of this process we've learned a great deal from talking to enforcement officials, what we realize is that nothing we are saying is intended to impugn the integrity or the goodwill or the impartiality of actual individual officials. That they all work in doing tremendous public service in the correct spirit. But even if they do attempt to do that to the best of their ability, what we all know from law is there's always a concern about the appearance of bias. Is that even if it is possible that someone with a financial interest in a case could be completely independent and completely impartial, but we would still nonetheless never accept that as a facial conflict of interest, not because of the reality, but because of the public perception. The other Latin phrase is audi alteram partem, which is listen to the other side. And what I'll say on the other slides as I give them to you, there's actually very sound theoretical reasons for doing that. They go far beyond the fact that it's old and in Latin. And so, that there is a modern scholarship that explains why it has emerged as such enduring principle. So the most modern of the things we've learned comes from cognitive psychology. Actually, to some extent, I'm drawing on the very excellent work being done by Walter Wills, who's a hearing officer for DG Comp, and in fact is uniquely well-suited to understand the process, and also to Judge Ian Forrester, who before entering the bench wrote some of the most influential articles really examining the impact of cognitive psychology. Also former FTC Chairman William Kovacic and others have written on this line. And what we've learned is that, in fact, there is a number of cognitive biases that can happen from associating with an agency. Your success becomes bound up with its identity. And in fact, what you discover that there is a tendency to align yourself with the goals of the agency. On a more fundamental level, there are two very well-known biases, cognitive biases, which is confirmation bias and hindsight bias. And this has to do with the formation of the timing of when you form initial opinions and final opinions. Confirmation bias is actually fascinating. It says you make an early decision on a case or on a particular matter, and that early commitment tends to filter out other information and affects how you see the rest of the decision making as you go through the decision making. Probably the most famous example of this is a book called Essence of Decision by Graham Allison. And for those of you who know, among academics, it's often ridiculed as an example. He became dean of the Harvard Kennedy School, and people said no academic has gotten as much leverage out of a single book out in their entire career as Graham Allison did out of this book. But what he did is he applied modern cognitive psychology to the Cuban Missile Crisis. And he learned that, in fact, during crisis decision-making, people will form early opinions along the lines of confirmation bias and continue to adhere to it in the face of additional information that came in later, tending to disprove the initial hypothesis, which is formed under time pressure. And when you have less time pressure, you still adhere to it. And the concern is that in the enforcement context, someone who's involved in the early stage of an investigation will make up an early presupposition of the outcome, will learn more about the case, but will in fact have a filter on that subsequent information provided by the initial opinion. Hindsight bias works in the opposite way. Hindsight bias is at the end of a proceeding, there is a tendency for all of us to look back and think that the event could not have unfolded any other way. And I find that when we teach, among my many sins in life, I went to business school before I went to law school and was a practicing business person. And business school is famous for doing case studies of business propositions and business matters. And what's quite interesting about those case studies is if they're written after the fact, they have a certain sense of inevitability and fail to capture the act of decision making. That is an example of hindsight bias. Is once you see the end of the case, it has a tendency to seem inevitable. And in fact, the concern is that having reached the end of that, having the same person reaching that end decision makes it difficult for that person to then step back and evaluate, has the burden of proof really been met? Has justice really been done? And in fact, what we see is Walter Wills actually in his initial article that laid out some of these ideas, looked at the success rate of DG Comp in front of the general court and regarded that as some empirical evidence of the fact that these biases exist. That result, as Advocate General Pitruzzella pointed out, is subject to multiple interpretations. It can be actually the excellence of the decision-making as well. Unfortunately, we lack the empirical tools to separate out those two possibilities. There is a wonderful economic literature on growth that says due process is directly attributable to economic benefits. And it's a really wonderful outcome, I think, in an era where every country in the world could use another few percentage points in their GDP growth. This has become absolutely critical. Part of this is respect for property rights, but part of it is fairness and due process procedures. The other thing that's quite interesting is there is a dimension about respect for the government. Some of the most interesting studies is that even people who benefited from an erroneous decision, from the failure of due process, and it was their selfish interests were served by the failure to do due process, that actually weakens their faith in the government and their long-term faith in the decision. For the simple reason that, yes, you may have won that round, but inevitably you'll be subject to law again, and the arbitrariness of the decision-making actually, there's no guarantee that that arbitrariness will work in your favor. And this has actually been empirically validated in many, many ways to actually show that it works to enhance people's faith in the government and their adherence to, it reduces enforcement costs, their adherence to the outcomes improves when they believe they had fair procedures. And I think that that's vitally important. And then the last interesting question, and we see this very clearly in different areas of the law, is that transparency in due process actually improves the coordination throughout the entire apparatus. One of the things we've seen in China, they have begun what they call the Fair Competition Review System, which they need to evaluate the behavior of low-level enforcement officials to make sure that it's actually consistent and up to the high standards the agencies set for themselves. But if you're going to engage in some sort of review system, there has to be something to review. And so there has to be a paper record and other things to identify. And actually, that's a famous line from US administrative law that if you're going to do administrative review, there actually has to be something to review, a record. And that, in fact, regularization procedures serve that value as well. There are other things we've talked about in the report, not the least of which is the educative functions that a more fulsome due process gives to non-parties in front of the court and the like. But I believe that I will stop there in terms of the theoretical justifications. So as Advocate General Pitruzzella mentioned, we do have three primary recommendations, one about agency disclosure, one about separation of functions within the agency between investigatory and prosecutory staff on the one hand and adjudicative staff, and the question about vigorous judicial review, in particular with respect to economic reasoning, but generally after the Mannheim case in Europe, it has to be plenary judicial review on all aspects. And then we do have 6 secondary recommendations, only 3 of which I mentioned here, and we will not talk about at great length, but I just mentioned them just for your information. One is the judicial review of document requests. You can do that. There are judicial review proceedings in the EU for inspections after the fact. There is an interesting question about the extent to which you can do judicial review of document requests. And in the US, you can put a motion to quash a document request and have judicial scrutiny of that. Allowing respondents to engage in more debate with the agency before the final decision is made. Admittedly, the statement of objections is a preliminary matter in Europe. There's an interesting question about whether the level of engagement and dialogue that can happen before that. But the most interesting one and the most innovative thing that we do in the US is if there is a proposed settlement of a competition law case, we have a very public notice and comment process during which the agencies have to disclose the economic basis of what they're doing, accept public comment for 60 days, and then respond to them and explain why the alternatives they considered and why the comments were not well taken. This is done in judicial procedures formally under what's called the Tunney Act to the Justice Department. It is done less formally under the Federal Trade Commission, under its administrative decision-making, but not by statute, but by voluntary practice. They actually comply with largely the same practice. And one of the interesting questions which we've seen happen here in Europe is questions about settlement and disclosure and the ability to make that more transparent. This is something that's engendered some interest in our conversations both in Europe and in China about whether that should be something can be considered to an innovation that we consider to be adopted in other jurisdictions. I do not mean to sugarcoat this. There is an active literature in the US saying the Tunney Act is largely useless, has not served its purpose, and so as all these questions are, they're inevitably ones of second bests, as Advocate General Pitruzzella mentioned, administrative costs versus error costs. And that's a difficult balance we have to make, but it is an interesting innovation which comparative analysis actually brings to the fore. I would say that it's quite interesting how, going to our first primary recommendation, how US administrative law has developed. And in fact, there's an active debate in the US as whether we've required too many hurdles. There's a concern that it's ossified agency rulemaking and made it too difficult to change. Other people think that it's an important and critical part. I hesitate to do what I'm about to do because it's anecdotal, and they always say that the plural of anecdote is not data. But the thing that I'm always struck by is I've become quite good friends with a number of European heads of European company offices in the US and Asian company offices in the US. Companies such as Deutsche Telekom and NTT, and they actually love US administrative law. Why? Even if they're strangers to the process, when they read a single order, actually the entire regulatory history, the arguments and all that is laid out completely before them, and it is the antithesis of closed-door decision-making, that in fact it is open for disclosure. This has been the primary innovation, and it's the belief that thoroughly ventilating issues is the best way to get to justice, particularly where judges cannot substitute their judgment for the substantive decisions of the agencies. And so in that case, ensuring that every consideration is given proper consideration by the agency is the best recourse. We have a number of automatic disclosure mechanisms under US administrative law where the agency has to reveal all of the facts that it's relying on and give the opportunity to the respondent to investigate these. And in our hearings, we do require full trial-type evidentiary hearings with cross-examination of questions by counsel representing the respondents. And this is perhaps a very distinctively US policy and a US approach, but it is something that we do in addition to the disclosure. And what's interesting, this is going to tie into the judicial review, agencies are only allowed to defend their decisions on judicial review on rationales and evidence disclosed in the substantive opinion they've moved forward. And this has a disciplining effect backwards through the decision-making process to ensure that they give proper disclosure and proper response to all of the different matters. On the division, the other major difference between US and other jurisdictions is how we handle administrative decision-making. We use a procedure called administrative law judges who are part of the agency, but are made as independent in many ways as we can make them. They are evaluated by a separate agency of the federal government called the Office of Personnel Management. They are advanced that way. Their raises are done by a separate agency within the federal government outside the enforcement agency. And that in fact they can only be fired for good cause. So they're given a significant degree of protection. And it's interesting, and they're prohibited from having ex parte communications with the enforcement staff, and in fact, their decision is appealable to the full FTC. Now, this is interestingly a hybrid, and when this was instituted in 1946 under the Administrative Procedure Act, they considered whether they should do full judicial enforcement the way the US Justice Department Antitrust Division is required to do. And they decided that there is some merit combining the expertise of the agency and as part of the decision-making and to proceed by administrative decision-making. But the compromise is for the reasons that Advocate General Pitruzzella mentioned in the Mannheim case, there are some concerns, so our solution was to create this internal separation within the agency. It's not complete. Officially, all actions are adopted by the full commission, just as they are in Europe. And at that point, the charging function and the adjudicatory function do meet. So it is a decision to make it a separation at the lower levels of decision. But the hope is by separating that, you'll avoid some of the cognitive biases and other appearances that we discussed before. And in fact, it deals with some of the incentives theory. One of the reasons that we only look at rationale stated by the agency, part of it is because the full commission adopts the decision, and they are the experts. They're the ones who've gone through the full political process. And we don't want to listen to a entry-level trial attorney's representation of what the agency thinks, because that may or may not represent what the full agency's expertise yielded. But more importantly, there's a real danger that a young attorney will attempt to make a career out of a case. And there's a huge temptation as a matter of practical control of a large agency with many heads that having some degree of discipline and separating those personnel actually can yield some benefits. And then lastly, judicial review. What I was quite interested to see is that there's one area in which US law provides less protection than Chinese and EU law, and that's with respect to review of facts. That administrative law in the US regards, with respect to fact review, it clearly treats the courts as the second instance and is largely deferential to the fact finder on the basis that they developed the trial record, they saw the testimony, they're in the best position to witness it in the beginning. There's very similar reviews of law, a plenary review of law in all three jurisdictions. What's most striking to me is the review of economic reasoning has historically been much stronger in the US than in other jurisdictions, but in the wake of the UPS case, this is changing clearly in Europe as well. That American law clearly requires disclosure of all economic models, assumptions, facts that go into it, and require that the respondents be allowed to take criticisms of that and to submit their counter evidence, to interrogate the evidence and the like. And the real belief is that this is the best way to avoid courts substituting their judgment by making it disclosed and fully ventilated on the record is the best way to create the kind of transparency that serves the justice functions, the educative functions, and the other functions that we associate with due process. I will stop there. That is largely the outline of the report in the US portion, and with that, I will turn it over to Professor Fetzer, who will talk about the EU.
Thank you, Professor Yu. I will be shorter. So we agreed that the introductory part and the US part should be the longest parts for two reasons. One is reason of time. Second, I'm kind of intimidated talking about EU law, about cases where many of you have been involved one way or the other. So I don't want to misstate or misinterpret something that you did. I should say, and Professor Yu has mentioned this, we labeled it as a final report, but in a way it's a preliminary report. Probably all academic work to a certain extent is always preliminary. And the more often I read the report, the more often I think I should add something here or there's something misstated here. So we have to apologize for having submitted a preliminary final report. And as Professor Yu mentioned, we are really looking forward to your feedback and your corrections. I don't want to go into all the recommendations that Professor Yu was mentioning, and I also want to focus on the first three recommendations that we have in this report. I should also say, and Professor Yu has mentioned this, when we say recommendation, we don't mean every jurisdiction should apply this or should introduce this the same way, because many of these things are somehow contextual and depend on the overall legal system and the societal system that you're in. So recommendation really means points that we think are important for due process and which can be improved one way or the other in different jurisdictions. I will again focus on the first three, and it has been interesting to me because one of the experiences of this project to me was being raised in a European country, being familiar with the European system. I've more or less thought it can't be any different than the way it is designed, and it can't be any better than the way it is designed. After having gone through this process, I still think it's a very solid system, but I can see some room for improvement after having learned also from other jurisdictions, which probably is not a big surprise. When it comes to the agency disclosure of the evidence, one of the most important points here in time is the letter of objection before the final decision. where the Commission basically has to disclose the economic theories, has to disclose the facts, the theory at harm, and a preliminary legal assessment. And in the UPS case, and also the statement by Advocate General Advocate General Kokot in this case, it has also been made clear that you cannot change the economic theories, the fundamentals after that, but if you want to do this, you have to either issue a new letter of objections so that the investigated party has a chance to react on that. One of the discussions that we had in our research group was, is this timely enough? And I frankly always thought it is the right time to disclose the evidence, because you always have to strike the balance, because do you really want to compromise the process by disclosing evidence too early, giving the parties the potential ability to hide further evidence, or do you want to make them nervous too soon? And on the other side, it can improve the quality of the outcome if you engage in a serious discussion with the parties or with the investigated party. So one of the questions that came up during our discussions, and I'm looking forward to hearing your comments on that, probably on the first panel mainly, but also on the other panels, is the timing correct here? Is it too soon? Is it too late? One difference that we found in the different jurisdictions, not so much between the US and Europe, is that we have to disclose exculpatory evidence too. That seems to be different in China. I think it's widely accepted here. The only thing, but that might be due to my naive reading of the Intel cases, which somehow puzzles me when you the Commission has to disclose exculpatory evidence, but the investigated party would have to prove that they could have relied on it, so that it could have been beneficial. And I have always wondered, how do you prove this if you not necessarily know that there is something there that could be helpful for you? So this is one of the problems, acknowledging it's an important decision, which I really have with it, and I would be happy to hear your thoughts on that. Separation of investigative and adjudicatory functions. There, Professor Yu and I probably had the most intense discussions, because in the US there's a strict, there is a strong separation within the agency, which we don't know the same level here in Europe. And there are two potential issues, and one was already mentioned by Professor Yu a couple of minutes ago. To my understanding, the Commissioner does not hear the cases here and will just, so it's delegated to DG Comp to investigate the case, but the Commissioner herself will not participate in the hearings and will not participate in this in the entire procedure. At the end of the day, it's a decision by the Commission or by the Commissioner, by the Commission, by the entire Commission or Commissioner. And the question is, does this cause any problems? The other things, and the Advocate General already introduced us to the Mannheim case, so I don't want to talk too much about this. Is it a problem that there's no separation of investigatory and adjudicatory functions? And so, first of all, I think there are some institutional safeguards, not strong institutional safeguards, to have some internal checks and balances. So the hearing officer, with all his limited abilities to intervene, the fact that legal service is going to be involved in all cases because a decision is issued. There's theoretically an internal overview by other commissioners, even though from the outside I'm not so sure how much this internal overview by the other commissioners actually goes. I really think the key here is the level of judicial review, and I think these are more or less communicating tubes here in a way. If you have a lack of separation of functions within the agencies, you need a higher level of judicial review. If you have a separation of functions within the agencies, the level of judicial review can be reduced. The reason why I'm saying this is I believe from a due process point of view, it's important that at least one independent second pair of eyes looks on decisions. And if you have ensured that this is within the agencies, you can be more relaxed about the judicial review, the level of judicial review. If this is not the case, you need to have a higher level of scrutiny towards decisions by the agency. Which brings me to the last point here, and that's the level of judicial review. Basically, you could say, and that's what Manorini required, and that's what theoretically happens, is that there's full judicial review, at least at the general courts, concerning the facts, as well as the legal assessment. I want to differentiate here a little bit. It's not quite surprising that there is no deference in a legal sense to the Commission's assessment of the legal, to the legal assessment by the Commission. I mean, that's what judges are for, right? To interpret the law, to apply the law. There is sometimes some discretion, but generally there's full judicial review. My understanding is that theoretically there's also full judicial review of the facts, even though I don't know if the court is really engaging in fact-finding. Surely not the ECJ, but that's not within its scope anyway. So I have the impression that there is still some deference to the facts found by the Commission, which I understand for many, many reasons. But I'm not sure if there's effective fact-finding or judicial review of that. If it comes, and that's always also a discussion that Professor Yu and I mainly had about the economic theories and judicial review, I think my observation is that the court is, over time, has been more willing to have a look at economic theories and to pay less deference to the economic theories as applied by the European Commission. I sometimes want to believe, and you can correct me here, it's that the court also has developed more experience over time in economics. Not saying that they're perfect economists, but my impression is the more cases you deal with, the more experience you get. If you go back to the UPS case that I just mentioned, and it's going to be interesting how this finally will turn out, it seems that the court didn't go into the different economic theories, but in order to figure out whether you change an economic theory from your preliminary or from the letter of objections to final decisions, you have to deal with them on a substance, right? I mean, if they don't just come by different names where it's easy to say you relied on A and in the final decision you said B and there's a difference and that you didn't explain. But my understanding is it was not that easy in the UPS case. So you have to deal with the economic theory in order to make the assessment if there has been a change, which I consider to be a further step to giving less deference in terms and to scrutinize the application of economic theories. So these are the three main recommendations that we actually come up with. I will skip the side, which I'm happy to talk about in the discussion or later words, just to sum up here a little bit. If it comes to the agency disclosure of the evidence on which the Commission wants to rely, from an outside perspective, the letter of objection might not be the perfect point in time, but my impression it's a reasonable point of time. Disclosing more evidence before could come with some problems, but I'm happy to discuss this with you. Separation of powers within the agency, as I said, much depends on the third point, how judicial review is applied. And there could be some improvements. So points 2 and 3 are strongly linked to each other. To the other recommendations that we actually have, and which are also somehow linked to each other, right to legal representation, you can discuss about whether in-house lawyers should participate in the legal privilege. That's one thing which you could debate. And publication of final decisions, I think it's okay. The one thing that I want to mention here is the fourth point, because Professor Yu also mentioned it. The question is, how much judicial review do you get on settlements and commitment decisions? I was having a brief conversation over breakfast this morning, and you arguably could say, if people settle something, why do you want to have judicial review if everybody is happy with what was coming out? I would say, first of all, it's not quite clear how happy all the parties are with it, because you can settle for different reasons. Second of all, and I know that's an old argument, but I still think it's true, if you want to contribute to the development of competition law, and we heard this morning, it's nice if you have cases that you actually can decide on, and if the number of cases is reduced, parties in the future will not really know what they can do and what they can't do if there is no court decision, no final decision issued by the Commission that then can get judicial review. Having said that, that was real quick. Again, we have plenty of time for discussions. I'm looking forward to your comments on that. And I would like to hand over to Professor Huang and Roger to give their view on China. I should say Professor Huang is, his English is excellent, but he brought one of his former students to give us some interpretation here, translation. Thank you.
Okay, morning. 我让我的这个助理也是中国非常优秀的这个反垄断的这个律师呢，来帮我做一个翻译，来介绍中国的这部分的一些背景。
So good morning, everyone. I will hand over to my assistant, who used to be my student, who is now a Chinese antitrust practitioner, to help me translate what I'm going to talk about China's part of due procedure.
那么首先呢，我也特别感谢我们这个报告的2位合作人，美方和德方，欧洲方面呢，给我们中国一个很好的一个机会。那么这个机会呢，也就是说，我们反垄断只有10年的时间，而且这个反垄断的最主要的案件都是集中在这近5年。但是这个实体和程序依然重要，对于中国来讲也是同样的这种结论。
Well, first of all, as the Chinese professor involved in this project on due process, I think it is a great opportunity for China to be part of it. One of the reasons is because China has only 10 years enforcement of anti-monopoly law, and most of the important cases happened in the last 5 years. And as a new agency and jurisdiction having competition law, we share the same understanding that procedure issues is of equal importance of substantial issues.
那么实际上对我们中国的这部分的撰写呢，实际上是非常困难的。那么这个困难点呢，有几个重要的重要的原因。一个就是说，我们的这个中国的行政执法的法治啊，还是在成熟的过程中。第二个呢问题呢，就是中国的这个历史啊，中国的习惯实际上是一个政府主导的发展的这么一个市场。向市场经济迈进的这么一个过程，所以说政府的这种行政的力量，政府的这种权威，在我们中国来讲，比较美国或者是欧盟来讲，可能政府的力量是更强大的。
Well, actually, when drafting this report and when discussing about these issues with our counterparties in EU and US, we find the drafting of China's due process is a little bit difficult because of the following reasons. The first reason is because the administrative enforcement of laws and regulations in China is still on the path to develop. We are trying to become a rule of law region. We are still on the way. So there are a lot of changes regarding the administrative enforcement, not only antitrust law, but other laws and regulations as well. And second reason is, historically speaking, because of the culture and the political system of China, of this country, our government agencies enjoy more power compared with the government agencies in EU and US. And our economy, in our market economy, government agencies is, to some extent, is a very important player. Or to some extent, we can say it is government-led economy development. With that being said, this background makes the situation in China more complex compared with EU and US.
那么另外一个问题呢，就是反垄断的这个执法的行政执法这个诉求，市场以及我们学界和全世界对我们的研究呢，其实我要讲一个背景，就是反垄断的这种行政执法的问题，包括程序刚才所讲的和我们报告里所列举的一些非常细致的一些问题，那么实际上是在中国的行政执法以及行政执法的这种诉讼法、强制法的整体的框架下的其中一部分，实际上应该是与中国的行政执法的它的程序是一致的。那么所以在这个方面，我们来研究，特别来研究反垄断法，可能也增加了这个困难。
And the last reason it is difficult is because as I have mentioned earlier, that the administrative enforcement in China is a whole package. Antitrust law is only part of it. However, the whole package of administrative enforcement is under the guidance of administrative laws and regulations in China. Therefore, antitrust law enforcement is of no exception. And to take antitrust law enforcement as a single part to be the subject of the research make it a little bit difficult, because not only you have to research the antitrust law and relative regulations, but also you have to respect the rules set by all the related administrative laws and regulations.
那在这个方面，我自己是有亲身经历的，因为我不仅仅是这个反垄断部门的这个国务院的专家，那其实我也是一些其他的行政执法部门，比如说过去的质监局、国家的税务总局，以及其他的一些政府的部门，我都是他们的这个法律的顾问的委员。那么我也经历了在这些部门它的执法中的一些遇到了执法中的问题。如果相比较而言，对于程序的这种诉求、程序的这种讨论，特别是这个社会的关注点来讲，可能反垄断法如果跟其他部门来比较的话，我觉得是还是进步的。
Well, also as the expert advisory committee of Anti-Monopoly Commission of State Council, I get involved in the whole process of legislation and enforcement of antitrust law. Besides that, I also served as legal counsel for taxation institution and also the quality inspection administration in China. And by working as these consultants to government agencies, I can personally involved in their administrative enforcement procedure. And based on my personal observation, I think the procedure of antitrust law enforcement to some extent is much better compared with other laws and regulations enforcement.
那么现在我们可以看到特别是这3年开始，中国在行政执法的这个方面有几个利好的消息。第一个方面就是关于民告官过去都是官赢多，完了民赢的少。那么从3年前，我们看我们的行政诉讼法开始一个大的一个幅度的修改，也就是解决民告官的问题。那么这个从它的这个调整它的主体以及收案范围以及它的时间等等，就是一个非常好的一个法律的修改。而且我们看到这几年的数字是蹿升，就是而且民告官的赢的比率越来越大，这就是其中的一个利好消息。
Well, with that being said, I would like to share the recent development of China's administrative enforcement, not only limited to antitrust law, as the following aspects. The first is a good news. In the past 3 years, we have a dramatic development in the number of cases involving individual citizens as plaintiff to sue government agencies. Before this, like many years ago, it is very difficult in China to bring a litigation against the government agencies. Even if the court accepted this case, it is a slim chance for you to win the case. However, 3 years ago, we have amended our administrative litigation law, and this major changes of administrative litigation law has not only altered the standing of plaintiffs, but also has expanded the scope of administrative litigation in general. And therefore, as a result, for the past 3 years, the numbers of cases that is administrative litigation with individuals as the plaintiff has increased dramatically.
那第二个利好的消息就是我们3家的执法机构过去是分散在3家，那现在终于今年合并为1家。那么在合并1家之后的其中的一项工作，就是对于过去3家的行政执法部门关于程序和实体的一些规定呢，现在要在一起修改整合，这又是一个契机，就是我们在研究这个报告的这个非常有利的一个契机。
Well, secondly, regarding antitrust enforcement, before this year, China has 3 separate agencies, which are MOFCOM, NDRC, and PSYC, and each administration has a bureau to enforce China's anti-monopoly law. After this year, we have a institutional redesign under State Council, and the three separated bureaus has the function enforcing antitrust law has been merged into one bureau under the newly established State Administration of Market Regulation, which is so-called SAMR. After the consolidation, now we have a unified antitrust authority in China, which is a good thing. And another good opportunity for our research in due process issues in China is after the consolidation, SAMR decided to amend all these separate regulations on procedure and substantial standards of anti-monopoly law drafted by previous three agencies. So during this legislation process, we can have the opportunity to work with the government agencies and to study what is the best path for procedure rules in China.
那第三个利好的消息呢，就是来自于法院的变化。那么我们看到，我们在这个起草这个报告的时候，在中国开了3次会议，每一次会议的法官啊，包括这个直接的中院和高院，特别是这个最高院的行政法官、行政厅的法官和反垄断业务的这个法官都参与。最多的一次，我记得可能有10几个法官同时参加我们这个报告的讨论会。那么通过这个讨论会，有一点是我们现在已经看到了这个非常好的结果，就是这个法官他们现在在审理行政案件的时候，对于行政部门的这种程序方面的处理要求越来越严，越来越高。那么不仅仅是对反垄断，也是对所有的中国的行政部门，这一点郁教授和Fetzer 教授都深有体会。第二点就是最高法院的这个 IPR 的这个厅成立，你解释一下它的这个作用主要的这个作用就是未来可能更集中对于专业的，包括行政的，有可能对于行政的这种诉讼的这种专业性的考量，可能更集中、更加专业，而且级别更高。
And thirdly, I would like to talk about judges and courts in China. And for our report, Professor Yu, Professor Fetzer, and I have held 3 discussions in China and in the last 2 years. And all of these discussions has attracted a lot of judges from intermediate People's Court, High People's Court, and Supreme People's Court from both administrative divisions and IP divisions. In China, IP division is in charge of competition law cases. And these judges are actively involved in the discussion and provided their insights and understanding, interpretation of the procedures should be obeyed by government agencies when they are enforcing the laws. I think Professor Yu and Fetzer can share the experiences, can understand the knowledge and independence of Chinese judges because of that. And also a good thing is, based on our discussion, we have found out that Chinese judges and courts have now set a very high bar for the requirement of procedure rules of government agencies when they are enforcing laws and regulations, not limited to antitrust law. So if there is administrative litigation, the court will examine whether the procedure rules regulated in the relative laws and regulations are strictly followed. That is the first condition. If that is if the answer is no, probably that will rule in violation of the laws and regulations by court. And the second aspect of good news from the court is this year, Supreme People's Court in China has launched their own reform. And after this reform, for the technical cases, which include patent cases, not all IP cases, but only patent cases, and also anti-monopoly cases. These 2 kinds of cases are considered to have very complicated technical issues and should be considered with tribunals with more knowledge and experiences. So after the reform, these 2 categories of cases, second instance, will go directly to Supreme People's Court. And there will be a division under Supreme People's Court responsible for the second trial, second instance of all cases involved with antitrust law and patent law, including private litigation and administrative litigation. This reform will have significant impact on future litigations and also will have impact on the development of procedure rules in China.
那最后我想用几句话来解释一下我们在报告里头的具体的建议中的问题。第一个问题就是关于查审分离的问题。查审分离的问题呢，其实 这个的相应的这种制度和这种名词，在我们中国的对应啊，直接对应可能是还是比较困难的。但是我们知道这个的查审分离的整个的西方，包括美国，包括其他国家，它的这种基本的含义。那我们现在只是一个雏形。张鑫给他解释一下，就是我们也是要希望做到这种独立性、公平性以及专业性，减少诉讼的败诉率，这也是我们一直追求的一种框架。但是可惜的是，我们的这个做法从中央到地方，它基本都是在一个部门的中的这种是不是实质的分离，我们还要去看那么这是一个问题。但是一个可喜的是，就是我们的证监会啊，已经实行了多少年？尽管是在一个大部委下，但是我们看到它的这种审理的人员以及它的专业性等等，都是超过所有其他的部委。所以这个的建议呢，在我们中国应当说是非常有作用，非常有意义的。而且我们自身的不是反垄断的这个委员会，而是其他的这个专业的委员会已经开始做了，但是跟他们说的行政法官这一套可能还有一定的距离，但是理念应该是一致的。
Well, at last, I would like to take advantages of the few minutes left to share some of my personal reflections regarding the suggestions we have concluded in our report. The first one I would like to talk about is the separation of investigatory and adjudicative personnel, which is a very important notion, speaking about procedure rules in Western countries. However, in China, it is very difficult to find an equivalent. We may not have the exact same mechanism as you share. However, I would like to say that we are absorbing this notion, and we're taking the importance of the separation of investigation and case reviewing, the case decision. But due to complicated restrictions at current stage of our nation, it is impossible to have this perfect separation of investigatory and adjudicative personnel. For example, in China's competition authorities, in this same bureau, we will have an investigation team from one division, and when the case was finally going to be decided, it will go to a case reviewing committee. And this committee is consisted of the DGs, responsible DDGs, and directors of different divisions, including the case handling team. But compared with the investigation team, it is not the same people. However, it is still within the same bureau. It is still under the supervision of the same official, of the same director general. So it is our separation of investigation and case reviewing so far. It is not perfect, not as mentioned by Professor Yu and Professor Fetzer. That is the major difference from China and the other two jurisdictions. But I would like to say we are trying to absorbing this notion, and we are trying to make effort to make it perfect. For example, not antitrust law enforcement. China has a commission called China's Security Regulation Commission, which is the so-called CSRC, the China's SEC. And this commission has successfully made their own experiences regarding the separation of investigation and case decision. It has a independent team to make decisions for each investigation. It even can hire, outsource outside experts and even judges to be their case reviewing team members, which is a big step forward, but that is not the situation for every agency in China. But this is a good example to show that the government agencies has realized the importance of the separation, and we're making effort to make it happen.
最后讲一下这个我们报告里谈到的经济学运用的司法审查问题。那这个因为反垄断法跟它有它自己的这种专业性，而且是经济学的这个运用在中国也已经开始在一些重大的案件中。那么现在的问题是我们目前没有，我现在看到的没有真正的行政机关做出了决定，完了到法院去诉讼在经济学方面的这种挑战。但是呢， 过去都是法院运用经济学，在它的这个著名的案例里头。那行政机构的几个大的案例，包括并购，都公布了是用的什么样的经济学的方法和理论。但是现在已经开始啊，我刚刚听到的是，已经有这个行政机构运用经济学的著名的案例，当事人请求的民事诉讼的案件。所以现在我们也期待着，就是在进一步的审理的过程中，对于行政机关所用的经济学的这个理论和经济学的方法，那么法院是一个什么样的态度？那么这个实际上也是检验我们未来的这个程序的这个改进的问题。
Well, the last suggestion I would like to discuss with you is the application of economic analysis in courts in litigation cases. Actually, we have to admit for administrative litigation cases in China, there hasn't been application of economic tools yet. However, the court has applied economic analysis and has consulted with economic experts in the private litigations, in the private antitrust litigations already. And here the latest development, based on what I heard, is there is a big decision made by Competition Administrative Agency in China who has applied a great deal of economic analysis being sued in court. This is administrative, being sued, not being sued by the plaintiff, but being sued by the third party. So it is a related private litigation. And the court is going to examine the economic analysis method adopted by government agencies and to review whether it is the proper one. And to greater detail, the court will also examine whether, to what extent has the government agency engaged with the target company regarding the application of economic analysis methodologies. For example, what kind of model has been used by the government agency. And because that is very important for the target company, whether they have the substantial right to defend their use of their own models. If they have no knowledge of the model adopted by government agency, then their right doesn't exist. So it is a very interesting case. It is still developing, and we're keeping a very close eye on it in order to find out the result, which we believe will have great impact on the future application of economic analysis by both court and government agencies, and also will also have impact for the development and perfection of the rules regarding application of economic analysis in antitrust cases.
那么我们中国的反垄断的诉讼程序问题也仅仅是刚刚开始，我们只有这么几年的时间，所以这也是我们共同的一个诉求，也是法治社会啊，法治的这个要求，就公平、公正、透明，以及对当事人的各种私权利的这种合法的这种保护。所以我们通过这个报告呢，我们有很多的思考，也有很多的这个下一步的讨论和改进。谢谢大家的聆听。
Well, with that being said, I want to conclude to say that with the few years history and experiences of China's anti-monopoly law enforcement, we have just begun our enforcement, just begun our litigation, and just begun our research on procedures. I think it is a very important topic because it's not only catering to the protection of very important private rights, but also it is the internal need for a rule of law society. So with this draft report, we welcome any comments and welcome any suggestions, and with the joint endeavor, hopefully we can perfect our report and make great contributions to jurisdictions all over the world. Thank you.
Thank you.
So thank you very much, Professor Huang, for this inspiring introduction and your remarks. There will be a coffee break, as you all have been attending many conferences. If we are running late, it means that we will shorten the coffee break, because I know that many of you will have to catch planes or flights or trains or something like that. So I would like to ask you to be here back again in 15 minutes, so shortly after 11, when we then gonna start with our first panel discussing the disclosure of the evidence part of our recommendations.